Okay, this is file 24-21759-FH, People versus Jeremy Allen DeVries. We are set for sentencing today. We are proceeding today in person. First, can I have Ms. Underwood place your appearance on the record?
Rhonda Underwood for Mr. DeVries this morning, Your Honor.
All right, and sir, you are Jeremy Allen DeVries?
Yes, sir.
Mr. DeVries, have you had an opportunity to read and review your pre-sentence report?
Yes, sir.
And have you had an opportunity to discuss that report with Ms. Underwood?
Yes, sir.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, sir.
Do you wish to explain or challenge the accuracy or the relevancy of any information that's in the pre-sentence report?
It's
We
my
just
military.
had one correction, Your Honor. Mr. DeVries did serve 2.5 years in the U.S. military, Your Honor, and he was in Iraq for 8.5 months. And I believe the basic information form says no military.
I have all the paperwork right here, Your Honor. So
It's okay, Mr. DeVries.
Mr. DeVries, do you know what years you served?
2004 to 2006.
Thank you.
That's
I have his medical documents where that's confirmed, Jennifer.
Oh, perfect. Can I
There you
have a copy of those maybe when we're done?
Right here,
should be in the last page.
which
That's probably right. He served military for 2.5 years before the Iraq War.
okay.
If you want to hand that to the bailiff, we'll make a copy of that for Ms. Walsh. And then we'll update that pre-sentence investigation report for you take it up to Francis. And she'll-
Thank you, Your Honor.
All right, any of the other information that in the pre-sentence report that we need to address?
We believe the rest of the pre-sentence report is accurate.
All right. This pre-sentence report disclosing prior convictions in which there existing known constitutional defects.
It does not, Your Honor.
And the probation officers calculated the minimum sentencing guidelines in this case to be 14 to 29 months. Do you agree with that computation of guidelines?
We would agree with that calculation.
All right. Before the court passes sentence, then, is there anything, Ms. Underwood, that you'd like to say on behalf of Mr. DeVries?
Yes, Your Honor. Mr. DeVries, Your Honor, obviously has mental health issues. Mr. DeVries has not had an easy life. The medication he takes in prison, I don't think is terribly effective, Your Honor. I think Mr. DeVries, under ordinary circumstances, if he was able to be treated properly, would not commit these crimes, Your Honor. He understands that what he did gets him in trouble, and he understands that he has to pay for that. And that's why we're here today. The probation department has recommended the top end of the guidelines, Your Honor. I would respectfully request that the court perhaps go lower than that. Mr. DeVries, Your Honor, I think really does have some challenges, and that's where we are today, Your Honor. Thank you.
All right, Mr. DeVries, is there anything you'd like to say on your own behalf before the court passes sentence?
I mean, guy was a child molester. He made a remark about my fiance's nephew. And I just reacted off impulse, you know. It's not an excuse for what I did, but stabbing all the guy because that is not a reason, you know. It's not. So I goes back to the corner, you know.
All right. In determining the appropriate sentence in the case, the courts consider the seriousness of your offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, report and recommendation of the probation department, as well as what's been said on the record this morning. The criterion reasons for the sentence are the nature and gravity of the offense, discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. So Mr. DeVries does have 14 prior felony convictions and 1 prior misdemeanor. There are numerous convictions for possessing a weapon in a prison, assaults within the prison. And this is unfortunately the latest instance of that. And it just, at this point, it can't be, I don't know what more to do. This can't be tolerated. You can't harm people. This was a particularly violent assault. I see these with some regularity, but you had a weapon consisting of a nail attached to something that you stabbed another inmate with, and that's making it dangerous for, you know, not only obviously the person that you harmed, but for everybody else that's in the prison. And as I said, it's happened numerous times previously. So the higher end of the guidelines is appropriate in this case, just given the number of times that you engage in this kind of behavior. So it's going to be the sense of the court that you serve 2 years and 5 months to 4 years with credit for 0 days served. You must pay $130 crime victims' rights fee and $68 state cost. That sentence is required to be consecutive to any sentences that you're already serving. Bailiff's going to hand to you 3 copies of a notice of right to appellate review and request for appointment of attorney form. You'll need to sign 1 copy of that form. Just indicates that you received your copies of those forms.
Yeah. Yeah, initial.
If you want to appeal your sentence, Mr. DeVries, you'll need to fill out the other copy, one of the other copies of that form, and mail it to the address in the form within 42 days. Or if you know now that you want to appeal your sentence, we'll give you time to fill that out and give it back to us before you leave the courthouse today.
Your Honor, is there any way guys can get your like holding stuff cleaned up? Because there's puddles of urine in there. I don't know why they're putting guys in there with multiple puddles in there. I was in there for like fucking 20 minutes. I tried getting the sealed attention. I had basically pretty much yelled to get their attention, but there should be no reason guys should be in humane conditions like that in a holding cell with no facilities to use bathroom with puddles of urine. So you should go back there and look yourself.
All right, I will do that. Is Mr. McGee here? Okay, Ms. Demont, are you ready with Mr. McCormick?
Yes.
Okay, we are on the record in files 23-21647-FH and 24-21705-FH. People versus Wesley Allen McCormick. We are here today for sentencing these cases. We are proceeding today in person. First, let me ask Ms. Demont to place your appearance on the record.
Kevin Dumont for Mr. McCormick.
And sir, you are Wesley Allen McCormick.
Yes, Your Honor.
Mr. McCormick, you had an opportunity to read and review your pre-sentence report.
I have.
And you have an opportunity to discuss that report with Ms. Demont.
Yes,
Are you satisfied with Ms. Demont and the advice that she's given you?
I am.
Do you wish to explain or challenge the accuracy or relevancy of any of the information that's in the pre-sentence report?
No, Your Honor, he would just like the court to know that he already did get his DNA on file and has been fingerprinted. I know that was in there. He's questioned about that a little bit and wanted me to let you know that he already has the DNA on file.
Okay. Does the pre-sentence report, Ms. Demont, disclose any prior convictions in which there are existing known constitutional defects?
No, Your Honor.
And the probation officer has calculated minimum sentencing guidelines. Filing 647 be 0 to 17 months. Do you agree with that computation?
Yes, Your Honor.
And in filing 705, they've calculated 0 to 9 months. Do you agree with that computation?
Yes, Your Honor.
All right. Before the court passes sentence, Mr. Demont, is there anything you'd like to say on behalf of Mr. McCormick?
Yes, Your Honor. The plea agreement was agreement to no upfront jail deferred 60 days. Mr. McCormick is approved for drug court and is ready to start. We have been in communications on how to get him for the past few weeks on how to get him on drug court bond conditions. Unfortunately, I did not hear back, so I wasn't able to advise him on what to do with that. He has done 4 drug screens since he has been back from Bowling Green, Ohio. Those have all been clean. He's in contact with Catholic Charities to start up his Parkside to start back up his counseling that he had previously, and we did provide the court with that. He has an appointment Thursday at 10 to start back up with them. When arrested on that underlying offense, he's compliant with officers both times, has never missed a court date. He did try rehab on his own. Unfortunately, that wasn't the right fit for him. It was religious based. He didn't know that before he was going in, but he does believe drug court will provide him with the right resources and community to combat his substance abuse issues and be a productive member of society. His criminal history is minimal, non-assaultive, and being drug related shows the court that drug court is his best option for him in rehabilitation. He has a strong family support, helping to keep him sober and successful. He has a daughter that he wants to be sober and successful for, and we would ask the court to take all of that into consideration with sentencing.
All right, thank you. Mr. McCormick, is there anything that you would like to say before the court passes sentence?
No, Katie, pretty much I covered everything great.
Judge, as far as testing, Ms. Dumont mentioned that he was clean his last 4 drug screens. That's incorrect. He is testing positive for marijuana still. It's been positive for the last 4. He does have a medical marijuana card, but it's my understanding he's not to use marijuana as part of his Bowling Green probation.
All right, and Ms. Teskey, he has been approved for drug court.
He has, Your Honor. My request at this time would be that he be ordered to go to the Lenawee County Testing Center today, and I would like to get levels for anabolic steroids and marijuana, and then he needs to be sending in samples once a week until he's clean. At his expense.
All right, I'm sorry, your audio was a little bit difficult for me to understand the last sentence. He needs to do what once a week?
Send in his urine samples once a week until he's clean at his expense.
Okay, that's fine. All right, in determining the appropriate sentence in your case, the courts consider the seriousness of these offenses, your history, the principle of proportionality, the statutory penalty, the cost of confinement, report and recommendation of the probation department, as well as what's been said on the record here this morning. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to their commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Have reviewed the pre-sentence investigation report. I do think that the recommendation here, including assignment to drug court, is the appropriate route to take in this case. The compass scores, I think, disclose the kinds of needs that can be appropriately addressed in drug court. And so, as indicated, I think that is the appropriate way to go here. So it will be the sentence of the court that you serve a period of probation for 2 years in both files. According to the following conditions, that you not use or violate any criminal law of any unit of government, you not leave the state without the consent of the court, you must not use or possess any alcoholic beverages or other intoxicants, you must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless you first have written permission from your field agent for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures, and you must present proper identification at the time of testing. You must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician or be with anyone you know to possess those items. You must complete outpatient or residential substance abuse treatment when you're referred by your field agent. You must complete a substance abuse assessment when you're referred by your field agent. You must make a truthful report to your probation officer monthly or as often as required by your probation officer, either in person or in writing, or as otherwise directed by your probation officer. You must notify the probation officer immediately upon any change of address or employment status. You must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer without need of a warrant. If the field agent has reasonable cause to believe that you have items which violate the terms of your probation. You must not drive a motor vehicle unless you first obtain written permission from your field agent. You must serve jail time of 34 days with credit for 34 days served in the file ending 647 and jail 4 days with credit for 4 days served in the file ending 705. You must pay a crime victims assessment of $130, supervision fee of $30 per month, which would be increased to $60 per month if electronic monitoring is required. Court cost of $750, DNA fee of $60, and state cost of $136. State cost would pay $68 in each file. So that
state costs are
So
going to, Your Honor,
I'm sorry, I'm sorry. So it's
on
100,
docket 21647, we have a $53 state cost for the misdemeanor, and then we have a 68 and 68.
okay, and
Because
so
the
the
state
total,
costs are per count.
yeah, sorry. The total state cost in the file ending 647 is $136. And so those are all the fines on the 647 file. In the 705 file, there's only the $68 state cost.
And then we have to add the $53 state cost to the misdemeanor in 47. The operating while presence of controlled substance.
Sorry, what was the state cost on the misdemeanor?
53, Your Honor.
Okay, so the state cost on the 647 file is $68 per felony and one misdemeanor. That's $189 altogether if I added that up. All right, so you do have the ability, and I'm sorry, you must also complete the Lenawee County Drug Court Program, if I didn't say that previously. You do have the ability to request an appeal of your sentence, Mr. McCormick. The bailiff is going to hand to you 2 sets of 3 copies of the notice of appellate, notice of right to appellate review and request for appointment of attorney form. There's a set for each file that you have, so you need to sign 1 copy of that document from each file and return that to us. That just indicates that you got your copies of those forms.
Your Honor, one more thing, I'm sorry.
Go ahead.
It appears that, since this is his first conviction, felony conviction out of Michigan, that there's a $60 DNA fee as well.
Your Honor, I believe
I think that was in the fine or the fees that I referenced in the 20.
Okay, I didn't hear that.
Okay, and so also Mr. McCormick will need to test, drug test today at the Lenawee County Drug Testing Facility as indicated by Ms. Teskey, and also provide a urine sample once per week.
I'm currently on colors right now, Your Honor, for my bond conditions.
Okay, so the bond conditions are going to go away as of today.
Right.
And so these will be the new conditions of your probation as we go forward.
Okay.
All right, and it looks like we also had a pending contempt charge that I'm going to dismiss at this time, given what the sentence has been. I think it's better to allow Mr. McCormick to proceed with the drug court program than pursue the contempt issue any further.
Your Honor.
Thank you very much.
And records are also reflected, you have the signed copies of the notice of appellate rights form from Mr. McCormick. I'm placing those in each of the files. So, Mr. McCormick, you are all set for today. Wish you luck with respect to drug court program. It's a lot of work, but it's very worthwhile if you're willing to
Thank
do
you
it.
very much.
Okay. Thank you.
Thank you.
Okay, Ms. Underwood, Mr. McGee is here by video conference.
I'm sorry.
Mr. McGee is logged into the Zoom
Oh.
session.
Thank you, Your Honor. Can I go back and speak to him for a minute?
Yeah, that's fine. Okay, Mr. Fry, you ready to proceed with Mr. Domshot?
Yes, Your Honor.
Okay, this is file 24-21833-FH versus Gianni Donovan Domshot. We are here today for sentencing in this case. We are proceeding today by video conference. First, let me ask Mr. Fry to place your appearance on the record.
Brian Fry appearing for Gianni Domshot, who is seated next to me.
All right, and sir, you are Gianni Donovan Domshot.
Yes, Your Honor.
Mr. Domshot, he had an opportunity to read and review your pre-sentence report.
Yes, Your Honor.
Have you had an opportunity to discuss that report with Mr. Fry?
Yes, Your Honor.
Are you satisfied with Mr. Fry and the advice that he's given you?
Yes, Your Honor.
Do you wish to explain or challenge the accuracy or relevancy of any of the information that is in your pre-sentence report?
No, Your Honor.
Mr. Fry, does the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
I don't believe so, Your Honor.
And the probation officer has calculated the minimum sentencing guidelines in this case to be from 0 to 11 months. Do you agree with that computation of guidelines?
So, Your Honor, I have discussed this with my client. It's my opinion that OV15 was scored incorrectly. It should be scored 0. It was scored at 5. It should only be scored at 5 in a delivery case. This was a possession case. However, I've spoken, and that would change the guidelines to 0 to 9 months. But I have spoken to my client about that, and it's my understanding that despite being advised of that, he does not wish to contest it. But I do want to put that on the record.
Oh, yeah, I will. Yeah.
Sorry, that was 15.
Yes.
I don't know, the description even says, in the room Don Shaw was in, there was 13 grams of crack cocaine in the mattress. So I'm gone. It was a raid, there was drug dealing going on.
Okay, so I think there is information within the pre-sentence report that would support scoring OV 15 the way that it is scored. If Mr. Domshot does not wish to challenge that score, then I'm going to leave it scored as it is, because I think that the PSI discloses sufficient information to support the score. Anything else, Mr. Fry?
No, Your Honor, not on that.
All right. Before the court passes sentence, then, Mr. Fry, is there anything you want to say on behalf of Mr. Domshot?
Yes, Your Honor. So this incident is from a year ago. There was a delay in charging this for whatever reason. Mr. Domshot has been on probation since August. My understanding, he has been compliant with that probation. He hasn't had violations, and he's been doing well on that. He has these 2 prior convictions that occurred around the same time last year prior to going on probation. So the court supervision seems to be working well for him. He does live in Adrian. He was employed. He did recently lose his job, but he has been applying for new jobs. He just had an interview earlier this week, so he's actively trying to gain employment and, again, complying with the law and the terms of his probation. So we would ask that he be sentenced to a term of probation at this time as recommended by the probation officer. Thank you.
All right, Mr. Domshot, is there anything you'd like to say on your own behalf before the court passes sentence?
Yes, Your Honor. Just like Mr. Fry said, been trying to get my life together slowly but surely, and this new conviction that I've been convicted of cost me a new job that I've only been at for 2 weeks, and I had to call off a few days in a row while I was sitting in the county jail, and that cost me to lose a brand new job. And so since I've been free, I've been trying really hard to get a new job, and it's kind of hard when you have a conviction record and they look at you a different way, and some people don't want to hire you, but I am still trying. And I, just like Mr. Fry said, I got an interview Monday, and I'm just waiting for them to call me back this week. And besides that, Your Honor, that's all I have to say.
Judge, he has done a really good job on bond conditions. His last 23 drug screens have been completely clean, and he has not missed a single drug screen.
Great, thank you. All right, in determining the appropriate sentence in the case, the court's considered the seriousness of your offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, report and recommendation of the probation department, as well as what's been said on the record here today. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. So this is a bit of a unique situation in that Mr. Domshot has already been on probation, and this offense predates the offense that he was already on probation for. It does appear that he's done well on probation so far, and that given that probation is likely to be successful and effective going forward with respect to this offense also. And so I do think it is appropriate under those circumstances to adopt the recommendation of probation department that's within the pre-sentence investigation report. So it will be the sentence of the court that you serve a period of probation of 3 years, subject to the following conditions. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by your field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures, and you must present proper identification at the time of testing. You must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician or be with anyone that you know to possess those items. You must use prescription drugs only as prescribed to you by your licensed physician. You must complete a substance abuse assessment when you're referred by your field agent. You must complete mental health, domestic violence, battery intervention, or other recommended treatment following assessment by a qualified community-based service provider. You must not have verbal, written, electronic, or physical contact with anyone who is housed within an MDOC facility without the permission of the field agent. You must not have verbal, written, electronic, or physical contact with anyone that you know to be engaged in any behavior that constitutes a violation of any criminal law of any unit of government. You must not use any object as a weapon. You must not own, use, or have under your control or area of control any type or imitation of a weapon. You must not be within the company of anyone that you know to possess those items. You must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer, without need of a warrant if the field agent has reasonable cause to believe that you have items which violate the terms of your probation. You must pay a crime victims assessment in the amount of $130, $30 per month supervision fee that would be increased to $60 per month if electronic monitoring is required. You must pay a $750 report cost, $450 attorney fee, and $68 state cost. You do have the ability, Mr. Gomshot, to request an appeal. If you were going to send to you 3 copies of notice of right to appellate review and request for appointment of attorney form, you need to sign one of those and return it to the court. That just indicates that you got your copies of that form. If you want to appeal your sentence, you would need to fill out one of the other copies of that form and mail it to the address listed in the form within 42 days. Do you understand that, Mr. Gomshot?
Yes, Your Honor.
All right, so let's see, Ms. Holly, he probably already has a report date.
Yep, he does.
Okay, so just report to Ms. Holly on your next report date.
Thank you.
Okay, thank you, Your Honor.
Okay, thank you. You can go ahead and log out.
Thank you, Your Honor.
Okay, Mr. McGee, I'm going to put you in a breakout session with Ms. Underwood if you give me just a minute here.
All right.
And let's see, Mr. Malero, are you ready to proceed with Mr. Rakes?
I am, Your Honor.
Okay, we are on the record now in files 21-20570-FH, 21-20656-FH, 24-21776-FH, and 24-21777-FH. People versus Devin Dean Rakes. We are here today for sentencing in these cases, and we are proceeding today by video conference. Mr. Malero, would you like to place your appearance on the record?
Salvatore Malero on behalf of Devin Rakes.
Yeah, sir, you are Devin Dean Rakes.
Yes, sir.
I'm sorry, I need you to maybe speak a little louder. I wasn't able to understand what you said.
Yes, sir.
Okay. And Mr. Rakes, have you had an opportunity to read and review your pre-sentence report?
Yes.
Have you had an opportunity to discuss that report with Mr. Malero?
Yes.
Are you satisfied with Mr. Malero and the advice that he's given you?
Yeah.
Do you wish to explain or challenge the accuracy or relevancy of any of the information that's in your pre-sentence report for the new offenses or the updated pre-sentence report for the probation violation offenses?
I would, but I would like Malero to go further on that.
Okay, Mr. Malero.
What was the question, Judge?
Do you wish to explain or challenge the accuracy or relevancy of any of the information that's in either of the reports?
Oh, there's just a question of the calculation of credit days, Judge. That's, I think, Mr. Rakes' main contention.
Okay, having a hard time hearing you, Mr. Malero.
Can you hear me now, Judge?
It's a little better, yeah.
I don't know where the microphone is. All right, so I was looking at, Mr. Rakes had a question about the credit on the violation of probation. My notes show that his mother had been advised to post his bond, and I think that happened, so I don't know how much, if any, additional credit he would get in the 214
Well,
days.
before I got sentenced, before I came here to Harbor Light, I served approximately 2 months in jail, and that's not reflected on any of the
Okay,
PSI.
we're getting there, Mr. Rakes. Okay.
Can I,
Yes, Ms.
can I,
Tesky.
can I interject?
Okay, I gotta have one person speak at a time because I don't know why, but nobody's microphone is doing a very good job this morning. And it's even more difficult for me to hear and understand when multiple people are speaking. So,
Okay.
so Ms. Teskey, what is it that you were going to say?
So, Your Honor, when he was arrested on 3/31, his bond was revoked. So I have made a mistake on docket 24-21776 and 21777. He should be getting credit for the days that I noted in that report, 3/12 to 3/24, but he should also be getting credit from 3/31 to 5/30 on both of those dockets, because his bond was revoked on 3/31. I will recalculate those guidelines, or I will recalculate that jail credit while you're doing your thing, but he does not get from 3/31 to 5/30, he does not get that credit on his VOP.
Okay. Oh, the other issue, Judge, is on the VOPs. Mr. Rakes thinks he paid some or all of these fines and fees. I don't know if Ms. Teskey can review that and verify that that's the case. He
I
said
will
that was a-
definitely review that his
He said
payment
that,
or non-payment was not the reason for my recommendation.
well, I understand. We understand.
I
that.
will definitely review that and make that right.
It might be it may be when that's the amount of the bond that was posted. So it may be a function that just needs to be applied.
Okay.
Okay,
I don't know when that hits their account.
right. So that may be what was going on. That being said, Judge, other than we're willing to waive any attorney fees in this matter, we have no other questions regarding the accuracy of the PSI or the violation of probation report.
Well, I just want to say that I think I should get the time for my violation, because I did post bond on that, but the time she's saying I shouldn't get credit for, I was in jail on a bond violation. So unless bond violation time does not count towards that, then that's correct. But if bond violation does count towards my credit time, it should be credited.
Okay, Ms. Teskey, so you said he did not get credit for March 31st to May 30th on the violation of probation. Why was that?
Because his bond was not revoked on the violation of probation. His bond was revoked. It was a violation of bond conditions on the new charges. So on the new charges that he's being sentenced for today, docket number 24-21776, his updated credit is 72 days. And 21777, his updated credit is 72 days.
So we did a bond violation in the new cases, but there was never a probation violation warrant in the older cases to trigger the credit. Is that what I'm understanding?
That is correct, Your Honor.
Okay, before the court passes sentence, then, Mr. Valero, is there anything you'd like to say on behalf of Mr. Rakes?
I would, Your Honor. We do not object to the calculation of the guidelines. We think they're accurate and to the pending felony charges. I would say this, Judge, Mr. Rakes is 30 years old. He has a considerable history of misdemeanors and felonies on his record. But on May 30th, this court was gracious enough to allow Mr. Rakes a bond that sent him to Harbor Light, and he is still at Harbor Light. He's indicated both to myself and Ms. Teskey that his youthful life of creating havoc and getting in trouble, he's tired of it. He wants to change. And I know the court hears that, but this is what Mr. Rakes has done to show the court that he means what he says. He's in Harbor Light. He's been there. He's either completed or about to complete the program. And his plan going forward is to not come back to Adrian, other than if he's required for probation purposes. And to stay in Monroe so that he stays away from the outside influences that usually cause people to make bad decisions. He intends to obtain employment there and become self-sufficient. And I think also importantly throughout this process and even going forward, he has the support of family members, specifically his mother. So he has demonstrated, I think, to this court that he is serious about changing his ways, becoming a law-abiding, productive member of society. It's quite frankly a lot of times when I have clients who say, I want to go to rehab for this or rehab for that, they just use it as a means to get out of the jail so then they can take off. Mr. Rakes has not done that. He's made good on his desire to be over this kind of life. He wants to lead a law-abiding life. I would ask the court to consider whatever sentence that's been recommended in terms of incarceration be suspended upon his good behavior while on probation, and allow Mr. Rakes to continue to demonstrate to this court that he means what he says. And that would be our request, Judge.
All right, Mr. Rakes, is there anything you'd like to say on your own behalf before the court passes sentence?
Yes. I just want to say that, I was really grateful that I was given this opportunity to even come here. I didn't expect that. And, I was facing quite a lengthy amount of time. And it really got to me, made me realize a lot of things about my life, that I'm not making the right decisions that I need to make. So I'm grateful enough that I was able to come here. I could have completed here 2 weeks ago and been out of here, but I didn't want to do that. I wanted to keep getting the help I was getting and just go slow and make a plan. And that's just, I made mistakes, but I feel like I'm getting old. I feel like I'm just trying to, I just want a different life. I experienced being part of society, and I want to go back to that. I'm just really tired of being in jail and being on the run and the anxiety that comes with it all. I'm just trying to start over, and I'm trying to just do the right thing one day at a time as best as I can. And that's all I got to say.
Mr. Coase, was there anything that you wanted to add?
Judge, he's been on treatment since May 30th. He does have an extensive history, bad drug problems. So, he's done a good job going to treatment and staying there, and he's doing a good job.
Right. In determining the appropriate sentence in these cases, the court has considered the seriousness of the offenses, your history, the principle of proportionality, the cost of confinement, the sentencing guidelines, report and recommendations, probation department, as well as what's been said on the record this morning. The criteria and reasons for the sentence of the nature and gravity of the offense, discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law in the protection of society. Mr. Rakes is 30 years old. He has 4 prior felonies and 13 prior misdemeanors. In the new cases, the convictions are for possession of a controlled substance and aggravated assault. The aggravated assault stemming from incident in which he and other inmates at the jail assaulted another inmate. Apparently in an effort to make him look bad for the trial that he had coming up, which ultimately had to be rescheduled due to the condition that that inmate was left in. And so in addition to the obvious, the injuries that were inflicted upon Mr. Parker, it also, it had the collateral consequence of causing disruption to the judicial system. And so I think that needs to be accounted for, particularly in light of Mr. Rakes' prior history. He had a lot of chances before this happened. And so I think that the recommendation from the probation department reflects that, and it's appropriate for the court to adopt that. So it's going to be the sense of the court with respect to file 24-21776-FH and 24-21777-FH that Mr. Rakes served period of probation for 3 years. Must not use or possess any alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site. unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. You must present proper identification at the time of testing. You must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician or be with anyone that you know to possess those items. You must complete outpatient or residential substance abuse treatment when you're referred by your field agent. You must not have verbal, written, electronic, or physical contact with Bo Parker, either directly or through another person. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer, without need of a warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week, unless engaged in an alternative program approved by the field agent. You must provide ongoing verification of employment or alternative program to the field agent. You shall not give reason to be terminated or voluntarily terminate your employment or alternative program unless you first obtain written permission from your field agent. You must serve jail time of 9 months with credit for 72 days served. You must pay a $30 supervision fee. It's increased to $60 per month if electronic monitoring is required. You must pay a $750 court cost, $450 attorney fee, and a $68 state cost. All those are with respect to the 776 file. With respect to the 777 file, it's sent to the court. They served 9 months in the Lenawee County Jail with credit for 72 days served. Must pay a $130 crime victims assessment and a $68 state cost in that file. With respect to the probation violation files, I think given the sense in the other cases, what I'll do in this case is just terminate probation unsuccessfully at this time.
Judge, may he have until like Saturday or Monday to report to jail?
I'm sorry, I couldn't hear you, Mr. Malero.
Judge, since he's at Harbor, could he have a few days to report? I don't know how it works to get out of there, but. Did you hear me, Judge?
Yeah, I'm sorry, I'm just looking at the calendar.
Oh.
All right, so what I'll do is give Mr. Rakes until Tuesday, July 16th at 5 p.m. to report to jail. All right, Mr. Rakes, you do have the ability to request an appeal of your sentence. We're going to send to you or we'll have for you at the jail 3 copies of a notice of right to appellate review and request for appointment of attorney form in each file. You'll need to sign 1 copy of the form in each file and return it to us. That just indicates that you received your copies of those forms. If you want to appeal your sentence, you'll need to fill out a copy of the another copy of the form in each file and mail those to the address listed in the form within 42 days. Do you understand that?
Yeah.
All right. So we're all set then. You can go ahead and log out.
Thank you, Your Honor. I think that's it for me, Judge.
Okay. Thank you, Mr. Miller.
Have a good day.
All right, so are you Mr. McGee?
Yes, sir.
Okay. All right, Ms. Underwood, are we ready with Mr. McGee?
We're ready to proceed on Mr. McGee, Your Honor. Thank you.
All right, so we are on the record in file 23-21513-FH.
Your Honor. Could we have the live stream discontinued, please?